15 cents. All right. Hi, everybody. My name is Ursula Ramsey. I'll be the bailiff for round three. And as it said in our chat, we're just waiting now on our judges. So if you guys could we run through and make sure that everyone is here from both of our teams? So we're ready to go when they are.
Would you like us all to come on screen?
Sure, if you don't mind. We'll make sure everyone's cameras are good to go. And then see, looks like scrolling through. All right. Maybe waiting on one other person. All right. I will be keeping time. And then if you need to reach me, you can do so in the direct chat. And then as soon as all of our judges are here, we'll reconvene and then get started. So any questions from you guys or anything you need while we wait?
The planet would love the opportunity to practice, make sure our screen sharing function is working, and at the same time, we can show opposing counsel the enlargements that we intend to use, so we can kind of kill two birds with one stone there.
All right, let's do that if you guys want to go first, and then we'll let our defense team, if you guys would like to make sure all of your technology is working that way too. So that would be great.
Perfect, thank you. That's all we've got.
All right. Defense, would you guys like to practice the share screen also? If not, that's okay. Okay. Perfect. All right. Well, if there's nothing else, then we'll hang tight for just a bit longer. We'll wait for our judges to get here, and then we'll get started. So,
thank you.
See you in just a minute.
Yeah. Sorry. You can hear me breathing.
afternoon.
And Judge, I believe everyone is here, so we are ready to begin when you are ready.
I'm ready. If everybody's here, all right, we'll get started with the plaintiffs. I'd like to introduce their team.
Yes, Your Honor, we do have introductions and some preliminary matters. Would it be proper to do both at the same time?
Yeah, you can do them both same time if you want to. You introduce, and then we'll go over anything you want to cover and let the defense respond.
Perfect. Thank you, Your Honor. I'm Ansley Skipper. We are team S05. We represent the plaintiff, Ms. Bryson Saylor, in this matter. I will be directing Avery Andrews, crossing Ryan French, and may my co-counsel introduce themselves?
Yes, please.
Good afternoon, Your Honor. My name is Sonia Shrivastava. I will be delivering the opening statement, directing Bryson Saylor and crossing Taylor Tarr.
Good afternoon, Your Honor. My name is Ria Patel. I will be directing Dr. Cameron Carez, crossing the defendant Drew Jennings, and delivering the closing argument today.
And our witnesses will go next.
Good afternoon, Your Honor. My name is Lily Curlin, and I am Bryson Saylor.
Good day, Your Honor. My name is Anjali Shah, and I am Dr. Cameron Carez.
Good afternoon, Your Honor. My name is Ria Sharma, and I am Avery Andrews.
That's all of us, Your Honor. Just a few things to go over before the defense side. It's our understanding that Your Honor and the scoring judges have access to either digital or physical copies of the stipulations. Is that true?
Yes.
At this time, I apologize.
No, it's okay. I've got them pulled up here on another laptop. So I have them available, but you can go ahead if you want to enter those. It's fine.
We would at this time ask to enter those, Your Honor.
Any objection from the defense?
No, Your Honor.
All right. Anything else preliminary?
Yes, Your Honor. Just a few clarifications about mock trial rules that sometimes come up in trial. The first thing is that since we are not permitted to object during opening statements or closing arguments, we will save any objections that we would have made for after that statement or argument is over.
Okay.
Similarly, we're not permitted to voir dire any witnesses, so we will save those kinds of questions for direct and cross-examination so as to go to the weight and credibility of the witness's testimony. Also, similarly, Rule 15 prohibits motions that are not provided for in the case materials. So that would include defense motions for a directed verdict and anything else not in the case materials, which I don't believe there are any in this case. Also, just to note, we are permitted redirect and recross under Rule 43. And we are told that under Rule 611B, cross is open as to scope as to any of the material of the case relevant to the issue at hand, but redirect and recross, there's no kind of limitation as to scope. According to Rule 611A, Your Honor has the discretion to preside over the presentation of evidence in the courtroom. So we'd appreciate, for the sake of timing, any guidance from Your Honor about whether the scopes of redirect and recross should be limited to the round of questioning before.
My general and rule, I guess, in court, and I follow what standard is, cross is open, as you said, but any redirect or recross will be limited to what was the redirect limited was brought up on cross exam, and any recross of that will be limited to what was on redirect. It's just to move us along so we won't just spend a lot of time.
Understood. Thank you, Your Honor.
Right.
As you can see in the stipulations, the parties have issued to a number of issues in this case, including in Stipulation 9, the authenticity of all exhibits, which have been pre-marked as Exhibits A through F. Just to point out, this is a stipulation of the exhibit's authenticity, but no exhibits are considered pre-admitted. And we also provided for, under Competition Rule 18, do have a slideshow of enlargements of these exhibits, which we may use that have some highlighting and some zoomed in portions, as we would do, if we were going to highlight something in a physical courtroom, and we have shown these to opposing counsel with no objection. Mock Trial Rule 17, permits bench conferences at the court's discretion when we ask to call one, but requires that they take place in open court so that the jury is only constructively absent for scoring purposes. And also related to objections, as Your Honor probably knows, this year, because of the virtual format, the competition rules limit objection battles to just an objection explanation, a response from opposing counsel, and then a rebuttal from the original objecting attorney. And with that, I believe the plaintiff is ready to begin.
All right. Defense would like to introduce your team.
Yes, Your Honor. I'm Sophie Chang on the defense, which will be representing Drew Jennings in this case, and I will be directing Taylor Tarr. Drew Jennings will be directed by my co-counsel, Russell Overton.
Good morning, or good afternoon, Your Honor.
And Ryan French will be directed by Brent Driver.
Good afternoon, Your Honor.
Our witnesses then will be Drew Jennings, played by Madeline Jones.
Good afternoon, Your Honor.
Taylor Tarr, played by Ruby Baker.
Hello, Your Honor.
And finally, Ryan French, played by Jason Jung.
Hello, Your Honor.
And with that, I believe the defense has no preliminary matters to go over.
Your Honor, if I may, one matter that occurred to me when we went through the introductions again was that, to point out, just for everyone's to be on the same page, under competition rule 11, all of the witnesses are considered pre-sworn because of the virtual competition. I just wanted to make sure everybody was on the same page about that.
We can waive that if that's okay with defense. We'll just assume everybody's been sworn in and you can call your first witness.
Perfect.
Is that okay with the defense?
Yes, Your Honor.
All right. Okay. All right. If you call your first witness, please. Well, would you like an opening, plaintiff?
Yes, sir, we would.
All right.
Thank you.
Then go ahead.
As the Chinese philosopher Lao Tzu said, watch your thoughts. They become words. And watch your words because they become your actions. On September 5th, 2019, the defendant, Drew Jennings, turned her words into action, and the plaintiff, Bryson Saylor, was harmed as a result. Good evening. Today, you will hear about two competing chicken sandwich restaurants. We represent Bryson Saylor, the owner of Sailorman's, a long-established restaurant and icon in Poultry, Tennessee for 20 years. The other chicken restaurant, Eat More Chicken, owned and operated by Drew Jennings, is brand new and trying to establish itself in any way that it can. Drew Jennings wanted her restaurant to be as popular as Miss Saylor's restaurant. She wanted to become the new chicken king in town. Listen to the testimony about Jennings's ploy to take as many customers away from Sailorman's as she could. The proof will show that these tactics included social media slander. You will hear Drew Jennings's words through her social media account and through witnesses who heard what Jennings said. You will learn that the defendant created an anonymous social media handle to spread her lies about our client's restaurant. Through this anonymous account, the defendant's direct messages threatened Bryson Saylor, claiming that her chicken kingdom would crumble. On September 5th, 2019, Drew Jennings took the opportunity to turn her words into action. That action is why we are here today. As the plaintiff, we submit that Jennings put a sharp metal screw into the Eat More Chicken sandwich Jennings personally served to Bryson Saylor. You will hear how our client, Bryson Saylor, ordered a sandwich from the defendant, Drew Jennings. How Miss Saylor then swallowed a screw, experienced tremendous pain, and had to have the screw removed by doctors at the Poultry Community Hospital. Now, ladies and gentlemen, let's talk about the proof we will show you. Miss Saylor went to Eat More Chicken on September 5th to taste and assess her competitor's chicken sandwich. We will show that as Drew Jennings noticed Miss Saylor coming up to the register to order, Jennings rushed over with a toolbox in her hand. The proof will show that she then set that toolbox down at the register. Avery Andrews will tell you that Jennings pushed her out of the way to ensure that Jennings would be the one to take Miss Saylor's order. Our client, Bryson Saylor, will tell you that it was Drew Jennings, and Drew Jennings alone, who took her order and delivered the food. No one else handled her sandwich except Drew Jennings. Miss Saylor will then recall for you the moment she took one bite of the sandwich. And then she felt the sharp metal screw scraping down her throat. Miss Saylor will tell you that she felt unsafe in the restaurant, so she decided to drive herself to the hospital to get immediate medical attention. board-certified gastroenterologist Dr. Cameron Perez will testify that she found and removed a 1-inch galvanized metal screw from Bryson Saylor's stomach. Ladies and gentlemen, I want you to keep that toolbox I told you about earlier in mind, and how Drew Jennings placed it at the register. In fact, it has already been stipulated by both parties that Drew Jennings' toolbox contained a 1-inch galvanized metal screw. Now, back at the restaurant just after Miss Saylor left, Avery Andrews will tell you that her boss, Drew Jennings, the defendant, spoke these words. "That bully got what she deserved." Today, we bring this lawsuit against Drew Jennings for the tort of battery. Battery is the wrong done when an actor intentionally, unlawfully, and harmfully causes offensive physical contact with another person. We, the plaintiff, have the burden of proof, meaning we must prove our case by a preponderance of the evidence, or more likely than not. Our case will show that by a preponderance of the evidence, Drew Jennings' intentions were embedded in her words. These words were turned into unlawful and harmful actions towards our client, Bryson Saylor. And these actions resulted in the offensive physical contact of Miss Saylor swallowing a sharp metal screw. After hearing our case, if you think more likely than not that Drew Jennings turned her words into action and intentionally put a screw in Bryson Saylor's sandwich on September 5th, 2019, you must find in favor of the plaintiff, Bryson Saylor. Thank you.
Defense like opening?
Yes, Your Honor. May I?
Please begin.
Your Honor, ladies and gentlemen of the jury, today we will unfold the events of September the 5th, 2019. On this day in Poultry County, Tennessee, the plaintiff, Bryson Saylor, swallowed a metal screw while dining at a local Eat More Chicken restaurant. This franchise location is owned by our defendant, Drew Jennings. But Bryson Saylor and Drew Jennings did not know each other personally prior to this incident, only knowing that the other owned a successful chicken restaurant in the same small town. Drew Jennings has been a lifelong poultry resident. She grew up here, graduated, and only left to attend the University of Volunteers on a scholarship. A hardworking woman. And working through college is how Drew found her passion. She began as a manager in an Eat More Chicken franchise and is now an owner. Miss Jennings returned to her hometown of Poultry, Tennessee to open her own franchise and found immediate success. Sold out of chicken on the first day, and according to local media, has been the hashtag Chicken King ever since. But on September the 5th, the day Bryson Saylor swallowed the screw, Drew Jennings' dream was put at risk. Bryson Saylor swallowed a screw, and Drew Jennings was accused of battery. With everything to lose and nothing to gain, Drew Jennings has been put on the stand today by the claim that she wished to intentionally harm Bryson Saylor. By this claim, Bryson Saylor is suing for up to $1 million from the defendants on the civil charge tort of battery. The following elements must be proven to establish a case for battery. First, that the act must be made by the defendant Drew Jennings and no one else. Second, that there must be an intent to cause harmful, offensive contact on the part of the defendant, that Drew Jennings must have intentionally placed a screw there to cause harm. And third, harmful contact to the plaintiff, that there must be damage to Bryson Saylor. Today, we will call 3 witnesses. My co-counsel will first direct Ms. Drew Jennings. Drew Jennings will testify to provide her own personal account of the day's events. She had no intention of Bryson Saylor swallowing a screw. She never placed a screw there. She would never jeopardize her dream. Next, Taylor Tarr will be called by myself. Taylor Tarr has been Bryson Saylor's accountant for some time now and will testify to the timeline of Bryson's actions preceding the incident and will offer her own account of the day's events. And finally, Ryan French will be called to the stand by my co-counsel. Ryan is a manager at the Eat More Chicken where Bryson Saylor swallowed the screw. He's worked under Drew and will testify to the timeline of the incidents that day and the chaotic environment primarily due to the presence of protesters. These protesters introduced doubt into the equation. There is too much doubt to say that it is Drew Jennings who put that screw in that sandwich. Anyone could have wished harm on the plaintiff. Today, the burden of proof lies with the plaintiff. The plaintiff must prove her case by preponderance of evidence. Simply put, this means that the plaintiff must prove that it is more likely than not that the facts presented are true. Battery is defined as intentionally bringing unconsented harmful contact to a person. The plaintiff will not be able to prove this with a preponderance of evidence today. They cannot prove that it is 51% more likely than not that Drew Jennings was the person to place that screw in Bryson Saylor's sandwich. Therefore, at the end of this trial, we ask you, the jury, to rule in favor of the defendant, Drew Jennings. Thank you.
If there's nothing else, plaintiff, would you like to call your first witness?
Yes, Your Honor. The plaintiff calls Bryson Saylor. Please state your name for the court.
My name is Bryson Saylor.
And what do you do for a living?
Well, I've been working for over 20 years to perfect the art of the chicken sandwich. And I actually own my own chicken sandwich restaurant in Poultry called Sailorman's.
Why are you here today?
I'm here because I believe that Drew Jennings placed a screw in my sandwich while I was dining at her restaurant.
Who is Drew Jennings?
Drew Jennings is the owner of a franchise of Eat More Chicken, which recently opened in Poultry, Tennessee.
Now, Ms. Saylor, let's turn our attention to September 4th, 2019. How did that morning start for you?
Well, that morning I actually received some DMs or social media direct messages from a user called @#1chickenfan1 to my Sailorman's Twitter account.
At the time of this conversation, did you know who was behind @#1chickenfan1?
At the time, I did not know who the person behind @#1chickenfan1 was, but I was quite familiar with that username as they had been posting, malicious tweets and posts about me on social media and my business on social media for quite a while, making up rumors about my business and all of that sort of stuff.
At this time, I ask that the timekeeper display a copy of Exhibit D. Ms. Saylor, what is this a picture of?
So this is a screenshot of some of the social media DMs between @#1chickenfan1 and myself.
And is this an accurate representation of the conversation you had with @#1chickenfan1 that morning?
It is.
And just to clarify, which color text bubble are you?
So my texts are in the blue bubbles skewed to the right, and @#1chickenfan1's messages are in the gray bubbles skewed to the left.
At this time, I ask that Exhibit D be entered into evidence.
Objection, Your Honor. This falls under specific instances of conduct 405A and B. The opposition is free to talk about Drew Jennings or @#1chickenfan1 in whatever manner she likes in the form of reputation or opinion testimony, but cannot refer to a specific instance of conduct as this can only be inquired upon on cross.
Response?
Yes, Your Honor, just a moment. Your Honor, we are not going to, under Rule 405B, this is not an essential element of a charge or claim or defense. It is not to prove Ms. Jennings's conduct. It is simply to show the relationship that Ms. Saylor and Ms. Jennings have had.
Response? I think you can come back.
Yes, Your Honor. As the opposing counsel isn't using this to prove conformity, we do again turn towards 405A and B And under 4.5 A and B, specific instances of conduct.
All right, I'm gonna allow the exhibit to come in. Generally, when we have letters, Facebook posts, these kinds of things, they're quite common in trials now. As long as the proponent can say this is an accurate representation, just like a picture, this is accurate representation of what I got. It doesn't say who sent it. All she's saying is, so it's not being offered the truth of the matter asserted. This is just saying this is what I received. And I think that's allowable to come in. So I'm gonna overrule the objection. That'll be admitted as Exhibit D.
Thank you, Your Honor.
All right.
Now, Ms. Saylor, what was your direct message conversation with @1 Chicken Fan 1 like?
So through the Sailorman social media account, I like to keep things really lighthearted and fun. So I send a lot of, as you can see, GIFs, which are like moving memes. They're kind of jokes. And I use lots of chicken puns like bok off, sort of like how chickens go bok bok. But as you can also see, Drew Jennings or @1 Chicken Fan 1 just did not respond the same way.
How did @1 Chicken Fan 1 respond?
Well, they'd say things like, I think you're just jealous there's a new Chicken King in town, or going to enjoy watching your chicken kingdom crumble. And this is just kind of how @1 Chicken Fan 1 usually responded to the Sailorman's social media account.
Do you know who @1 Chicken Fan 1 is now?
Yes. Well, at the time of this conversation, I did not know who was behind @1 Chicken Fan 1. At this time, I do now know that @1 Chicken Fan 1 is in fact Drew Jennings, the owner of that franchise of Eat More Chicken.
At this time, I asked the timekeeper to take down the exhibit. So, Ms. Saylor, aside from these messages with Drew Jennings, what happened that morning?
Well, that morning, I also received some financial statements for the previous month.
Objection, Your Honor, improper foundation. The direct messages that were just shown were referring to September 4th, and Ms. Saylor is now referring to the events of September 5th.
Response?
Yes, Your Honor. In Ms. Saylor's statement, she said that she had received these Twitter messages and then she had heard about her financial statements. I'm going in order of the events that occurred, and this is how Ms. Saylor had said they occurred.
I'll overrule the objection. I'll give you a little leeway here.
Thank you, Your Honor. So, Ms. Saylor, what else had happened?
So that morning, I also received the previous month's financial statements.
And what were those numbers like?
Well, quite frankly, they were terrible. They showed we were down about 25%. So it wasn't good news.
And the next day, September 5th, 2019, what did you decide to do?
Well, I thought about it and I realized Eat More Chicken has been open in town for a little bit now, and I still haven't gone over to try out their sandwich and see what all they're doing over there. So I decided to head over to Eat More Chicken, get the customer experience there and see if I could learn anything about their chicken or their experience to come back and improve my own restaurant.
Ms. Saylor, once you arrived at the restaurant, what was the first thing you did?
Well, like I said, I wanted the full Eat More Chicken customer experience, so I got in line just like everyone else.
Once you reached the front of the line, who took your order?
Well, that's what's interesting. As I was standing in line, there was a Eat More Chicken employee who was taking orders. And all the way up to as I was waiting in line, that employee was taking everyone's orders. But when I got up to the front of the line, Drew Jennings actually came out of the back of the restaurant, pushed that employee out of the way, and took my order. She seemed very intent to take my order.
Now, Ms. Saylor, I thought you said Drew Jennings was the owner of the restaurant. As a business owner yourself, is it normal for the owners to take customers' orders?
No, personally, I simply don't have time to be upfront taking orders or
Objection,
even
Your Honor. speculation, this witness isn't qualified to speak on other restaurants, just on her own. Of course, they are running different restaurants.
Your Honor, may I respond?
Yes.
That is what Miss Saylor was doing. She was not testifying as to how Drew Jennings runs how Drew Jennings runs her restaurant. Miss Saylor was simply stating how she runs her restaurant and what is normal for her to do at Sailorman's.
Your Honor, terribly sorry.
Go ahead.
The question asked about restaurants in general and not specifically Miss Saylor's restaurant. Therefore, Miss Saylor's answer is being extended to other restaurants besides her own.
I guess, Ms. Chang, I didn't understand the question that way, but she was saying what she did at her restaurant, that she didn't give the chance to wait, she had other things to do. So I'm gonna rule your objection. I'm gonna allow the testimony to go ahead. All right, if you'll continue, please.
So Miss Saylor, just once again, as a restaurant owner yourself, do you normally take customer orders?
Personally, as a restaurant owner myself, I am busy with the business side of things. I have employees that I hire to take orders and make food, but I do not have time to be up front at the registers or in the kitchen. I'm in the back in the offices.
So Miss Saylor, what did you order that day?
I ordered just a standard chicken sandwich with a side of fries and a sweet tea.
And after Drew Jennings took your order, what did you do?
Well, I just went to a table to wait for my order to arrive.
Who brought your food to you?
Drew Jennings actually also delivered my order to me. And it took pretty long, about 10 minutes.
How was the food that Drew Jennings delivered to you?
It was decent. A pretty standard chicken sandwich. Honestly, though, I couldn't tell you that well because I only got one bite.
Why did you only get one bite?
Well, as I was swallowing that first bite, I felt this horrible pain in the back of my throat, and I just felt something like scratching down in the back of my throat. And I didn't know what it was. I just knew it was the worst pain I'd ever felt in my life. And I was so scared. I didn't know what had happened.
Did anyone in the restaurant offer you help?
There was a manager, I think, that came over and offered medical attention, but honestly, they were just a manager and I needed to see a professional. So I got myself in the car and drove straight to the ER to get the help that I needed.
Once you reached the emergency room, what happened there?
Well, I explained to the doctors in the emergency room that, I'd taken a bite of this chicken sandwich and I'd swallowed something really sharp and painful, and I felt like it was still inside of me. And then they did all of these tests and more tests and procedures. And finally, they found a screw inside of me.
Miss Saylor, did you just say that the doctors found a screw inside of your stomach?
That's right, like an actual inch-long metal galvanized wood screw with a pointy end and everything. It was just terrifying to know that had been inside of me.
Miss Saylor, do you know how this screw could have ended up in your stomach?
Yes, I believe that it was in the sandwich that Drew Jennings served to me.
Why do you think the screw was in the sandwich that Drew Jennings served?
I believe that Drew Jennings put it there.
Why do you think this?
Well, to start, Drew Jennings was the only person I ever saw handle my order. She took my order, she delivered it to my table. I never saw anybody else with my sandwich or my food that day. And then in addition, now knowing that at Number One Chicken Fan 1, that username that had been saying all those hateful things about myself and my business and spreading all these lies and slander on social media was in fact Drew Jennings, it's all come together, and I'm now sure that it was Drew Jennings who put the screw in my sandwich.
Thank you, Your Honor. No further questions at this time.
Cross-exam?
Yes, Your Honor. Hello, Miss Saylor.
Hello.
You're the owner of Sailorman's Chicken, right?
I am.
And Drew Jennings owns Eat More Chicken?
That's correct.
Let's move to the events of... Pardon?
A franchise of Eat More Chicken.
Yes. And let's move to the events of September the 5th. On September the 5th, you began the day waiting for Taylor Tower in your office, right?
That's right.
And before your meeting with Taylor Tarr, you received a direct message on Twitter from @1chickenfan1.
That's right.
You then received the financial statements from Taylor Tarr, correct?
That's right.
And your sales were down 25% from last year.
Unfortunately, yes.
At which point would you admit you were furious?
Yeah, I was upset. As a business owner, seeing your sales go down is, of course, as I said,
So
upsetting.
to clarify the timeline, you received the direct message, then your financial statements, and then was furious, correct?
That's correct.
Do you happen to have a copy of the exhibit that was shown earlier on hand? The direct messages.
I do not have a paper copy on hand.
If our timekeeper would put that onto the screen. Are you able to read that, Ms. Saylor?
Yes.
So you sent the first message, which says, "Hey, I know you're stealing my business and you better stop," correct?
Yes, the message at the top of that screenshot is my message.
Thank you. And then @NoOneChickenFan1 responded with question marks and said, "Don't have any idea what you're talking about, SMH," with SMH meaning shaking my head, correct?
Yes.
With which you responded with a GIF of fighting chickens and "Bok off or you're going down," correct?
Yes. The GIF is actually of two chickens slapping each other back and forth. And I just thought it was a funny analogy to how our conversations honestly had been going so far.
Ray can take that on the exhibit. But Ms. Saylor, isn't it true that when you received a direct message and then your financial statements, it wasn't so funny, you were furious?
I was really upset about my financials, but I've been in the restaurant business and the chicken business for a long time, and I know those numbers go up and they go down, and that's just kind of part of life. So I wasn't too worried about it.
Pardon. And thank you. And so when you were furious, you just probably screamed at your accountant, Taylor Tarr?
Yeah, I probably did.
And you're sure you slammed the desk or threw a pen, correct?
Yeah, like I said, I was upset about those financial statements.
So after this fit, you went directly to Eat More Chicken?
Yeah, I thought about it and I realized, I still hadn't been over there. I hadn't tried out their chicken. And so I thought it was high time that I head over and just see how it was.
And you drove there directly after, correct?
I did drive in my own car, yes.
Thank you. And Miss Saylor, when you arrived at Eat More Chicken, you described it as a madhouse and with people everywhere, correct?
Yeah, there were, the restaurant was pretty crowded. There was a long line.
And you got in line with everyone else, right?
Yes.
You ordered a chicken sandwich, some fries, and a sweet tea?
Yes.
And Drew Jennings took your order, right?
Yes. Yes.
And she was too friendly simply for asking how she may serve you and responding with "my pleasure"?
Well, yes. Since you brought it up, her demeanor was actually a little bit off when she was talking to me at the register. It wasn't really anything specific. She just seemed so friendly and fake, and it made me a little bit uncomfortable, to be honest.
But Miss Saylor, you would agree with me in saying that she was friendly, correct?
Yes, too friendly, in fact, is what it felt like. It felt fake.
And you tried the fries, right?
Of course.
Eating the rest of the meal, you bit into the sandwich?
I had one bite of the sandwich.
And the screw was an inch long, correct?
That's correct.
A length of 1 inch is about the size of half my pinky finger, Miss Saylor. You never felt a screw of that size in your one bite?
I did, actually. I very much felt that screw sliding down the back of my throat. It was the most painful experience I've ever had. And it was.
But you didn't feel it while you were, or before you swallowed it?
No, I didn't feel the screw until I was swallowing that first bite.
Miss Saylor, did you chew the sandwich?
Of course.
So you're claiming that you swallowed a bite larger than an inch in diameter and despite swallowing it, and despite chewing it, did not feel a screw?
I believe so.
Oh, sorry. Objection, Your Honor. Opposing counsel's question was argumentative. She was insinuating that Miss Saylor's testimony about how she chewed and swallowed her food was false, and her question was also a compound question, asking two questions in one.
I think she can question about how she chewed. I think it's a proper area, but I will let you rephrase, and if you would just ask one question at a time, Ms. Chang.
Yes, Your Honor, thank you. Ms. Saylor, I'll rephrase the question. So you're claiming that you swallowed a bite larger than an inch in diameter?
Yes, I swallowed the screw with the food, which the screw was an inch long.
And this was despite having chewed one bite of the sandwich, correct?
Yes, it was the first bite, which I naturally did chew. And then as I was swallowing is when I felt the screw in the back of my throat.
And just to clarify once more, the screw was an inch long, correct?
As I've said, yes, the screw that they found inside of me was an inch long.
And Ms. Saylor, you said earlier that you refused medical attention that the manager offered, correct?
Yes, this was a chicken sandwich shop manager. So naturally, I did not feel comfortable accepting medical attention from someone who's not a professional. I drove myself straight to the ER to get the medical attention that I needed.
But isn't another reason that you refused medical attention because, or that that Eat More Chicken was so crowded?
I also was concerned with calling an ambulance that they would take a long time, not only longer to get to the restaurant and back to the hospital than for me to go straight to the hospital, but that with all the crowds there, it might take a pretty long time for EMS to get in and out. So that's why I decided to drive myself straight to the hospital.
Thank you. And you claimed you could barely talk, correct?
Yes, I was in a lot of pain.
But it is true that earlier you yelled for help?
Yes, I could talk. I was in a lot of pain though when I talked, but I was terrified. And when that first happened, when I felt that screw in my throat, I was just terrified and I tried to get help as soon as possible.
So despite being barely able to talk, you'd managed to yell?
As I said, I was in a lot of pain, but I was also terrified.
So do you agree with that statement?
I did yell.
Thank you. And Ms. Saylor, when you got to the hospital, you went through a procedure and several tests, including an X-ray and an EGD, right?
That's correct.
And after these tests, you were informed you avoided serious permanent damage?
Thankfully, yes. I was told that if I had not gotten there fast as I did, and that there was a high potential that I could have had permanent damage, but luckily because I got there so quickly and the physicians there were so, wonderful, I was able to avoid permanent damage.
Ms. Saylor, you received a discharge summary, correct?
Yes, I believe so.
Rhea, if you would pull up Exhibit B. Ms. Saylor, is this a copy of the discharge summary you received from the hospital?
Yes.
And this was verified by Dr. Cameron Cares?
It appears so.
Is this a true and accurate copy of your discharge papers?
Yes.
Your Honor, at this time, we would now like to submit what has been marked as Exhibit B into evidence.
Your Honor, I would object to hearsay. This is a record under rule, actually, this is hearsay because and no proper foundation has been laid to enter this document under this witness.
Okay.
I'm not quite sure what the opposing counsel means by there was no proper foundation, but I can explain the proper foundation. First and foremost, this paper was verified by the doctor, which is essentially the same thing as an electronic signature. Secondly, as Miss Saylor has swallowed a screw and would be concerned for her well-being, she'd be able to recognize and identify this document. Therefore, this is exempt from hearsay under Rule 803 for medical documents for the statement of diagnosis or treatment.
Your Honor, in that case, this would be better suited under Dr. Carez, the expert witness, who is the doctor who performed all of these procedures. Ms. Saylor does not know how medical diagnoses and treatments are made, as she is not part of the writing of this document.
I think she can testify to what she got. She says she receives it from the doctor. She identified it as her discharge. And so again, going back like we did in the earlier objection, if it's identified as to what it purports to be, then I think it comes in. So I'm gonna overrule your objection. If you'll continue, Ms. Chang.
Thank you, Your Honor. Now, Ms. Saylor, according to these medical documents, you had no damage to the teeth or mouth.
Yes, it appears so. Thankfully, like I said, I was able to avoid permanent damage.
And your esophageal lining and interior walls of the stomach and duodenum appeared unremarkable, correct?
Yes, that's what the final report reads.
And you had no complications with the procedure.
Yes, again, I'm a patient. I don't really fully understand all of the medical lingo in here, but you're reading the document correctly so far.
Thank you. No further questions, Your Honor.
Any redirect?
No redirect needed, Your Honor.
Call the next witness, please.
The plaintiff calls Dr. Cameron Carez to the stand. Please state your name for the court.
My name is Dr. Cameron Carez.
And what is your occupation, Dr. Carez?
I'm a gastroenterologist.
Can you tell the court a little bit about your education?
Yes, of course. I went to Flex University in Medford, Massachusetts, and later attended Bostoniensis University Medical School.
Did you undergo any medical training?
Yes, so I moved to New York City after medical school to complete my residency at Beth Israel and later my fellowship at the University of Rochester.
Do you have any prior work experience?
Yeah, so I was in private practice, and that was for almost 10 years.
So then how did you find yourself in Poultry, Tennessee?
I wanted a change of scenery and was hoping to move to the South. I saw a job opening at PCH in their gastroenterology department. I applied and I got the job.
So how long have you been in poultry now, Dr. Carez?
For more than 15 years.
Now, you've told the court a lot about your training and experience. Do you have a curriculum vitae that also outlines this information?
I do.
And if shown this document, would you be able to recognize it today?
Absolutely.
Plaintiff timekeeper, please put up Exhibit A or Slide 2. Dr. Carez, do you recognize this document?
Yes, I do. This is my curriculum vitae.
And are curriculum vitae regularly used in your course of work?
They are.
Does it accurately represent your experience?
It does.
I now offer Exhibit A or Dr. Carez's curriculum vitae to be entered into evidence and published to the jury.
Any objection?
Objection, Your Honor. This is hearsay.
Your Honor, may I respond?
Yes.
While this is hearsay, it does fall under the exception 8036, records of regularly conducted activity, as Dr. Carez has testified that she both creates and uses these on a regular basis in her course of work.
Any response?
Your Honor, I believe records of regularly conducted contact is more in reference to specific persons regularly recorded acts of conduct, not necessarily within their field.
I'm going to allow the exhibit to come in. Curriculum like this, CVs like this are regularly used. It's one prepared for this trial. It's one that she testified she used in a regular course of business. So I'm going to overrule the objection, allow the exhibit to come in.
Thank you, Your Honor.
Please proceed.
Now, Dr. Carez, looking at your curriculum vitae, do you have any special certifications?
Yes, I am part of the American Gastroenterologist Association, and I'm also board certified in internal medicine and gastroenterology.
And for those of us that are less experienced in the medical field, can you describe what board certified means for the jury?
Yes, of course. Being board certified, at least in my case, means that I've passed the general internal medicine exam, which tests medical knowledge, clinical knowledge, and diagnostic skills. In addition to this, board certified physicians must have graduated medical education fellowship training to demonstrate clinical competence, procedural skills, and moral and ethical behavior in the clinical setting. Overall, being a board certified physician means that one has gone above and beyond that minimal standard in his or her particular specialty.
And in addition to being board certified, do you have any specific research experience in your field?
Why, yes, of course. I served as a sub-investigator for multiple studies with digestive dysfunction located at the Center for Digestive Disorders, and also served as a sub-investigator for ClinSearch, working in areas like gastric ulcer, gastroesophageal reflux disease, irritable bowel syndrome, and Helicobacter pylori, just to name a few.
I now tender Dr. Carez as an expert in the field of gastroenterology.
Any objection?
No objection, Your Honor.
She'll be admitted and will be able to give our opinion testimony.
Thank you, Your Honor, and thank you, timekeeper. Now, Dr. Carez, how did you become involved in the case of Bryson Saylor?
Well, I became involved in the case of Miss Bryson Saylor after she came into the ER on September 5th, 2019, and I was paged to the emergency room for a GI consult.
Could you explain what a GI consult is?
Of course. Giving a GI consult or a gastrointestinal consult means that I must tend to a patient who is in need of urgent medical attention. I must provide a diagnosis as well as treatment for their complications.
So on September 5th, why specifically were you called in for a GI consult?
So I needed to understand Miss Saylor's concerns and symptoms, and through this I learned that Miss Saylor was experiencing a severe abdominal pain after having swallowed a screw during her consumption of a chicken sandwich.
So after you completed your consult, what was your initial course of action?
I ran some tests, the first being an x-ray of Miss Saylor's esophagus and abdomen.
And what did this x-ray show?
This x-ray showed the location and position of a screw in Miss Saylor's stomach. Something the x-ray did not show though, however, due to its dimensionality, as well as the angle at which it was taken at, is the pointedness of the screw.
So if I were to show you that x-ray today, would you be able to recognize it?
Yes, I would.
Timekeeper, can you please put up Exhibit E or slide 15? Dr. Carez, do you recognize this document?
I do.
And what is it?
This is the x-ray that I ordered of Miss Bryson Saylor's stomach on September 5th, 2019.
Does it accurately depict the position and the location of the screw in Bryson Saylor's stomach?
It does.
And is taking x-rays a regular part of your job?
It is.
I now offer Exhibit E to be entered into evidence and published to the jury.
Any objection?
No objection, Your Honor.
That'll be admitted as Exhibit E.
Thank you, Your Honor. Now, Dr. Carez, can you describe for the jury what this specific x-ray shows in terms of Bryson Saylor?
Of course. This x-ray shows a screw in the lower left quadrant of Miss Bryson Saylor's stomach.
Thank you, timekeeper. So, Dr. Carez, after you located this screw in Bryson Saylor's stomach, what did you do next?
Obviously, I needed to remove the screw immediately. If not done so, the screw would tear Miss Saylor's stomach lining to shreds. Therefore, I performed an emergency endoscopic foreign body removal.
So why was this an emergency procedure?
This was not an elective procedure. Hence, I needed to remove the screw right then and there.
And what is an endoscopic foreign body removal?
So an endoscopic foreign body removal is a procedure used in cases where I must extract a foreign body from the digestive tract. I use a long, flexible tube with a lighted camera at its tip for inserting instruments through the scope, which I then pass down through the patient's mouth, into the esophagus, and then into the stomach, then pull back up from the stomach and out from the mouth.
So what were your medical reasons for performing this procedure?
Well, I needed to remove the screw immediately, as if I did not do so, Miss Saylor would face further abdominal pain, cramps, bloating, nausea. Also, the medical consequences of swallowing a screw include infection to one's organs. And last but not least, I'm really, really happy that I was able to remove that screw as carefully and as quickly as I did, as the screw would have just torn Miss Saylor's stomach lining to shreds.
So once you removed that screw from Bryson Saylor's stomach, what did you do with it?
I placed it in a secured surgical bag.
Would you recognize a photo of this screw if I showed it to you today?
I would.
Timekeeper, please put up Exhibit C or slide 10. Dr. Perez, do you recognize this document?
I do. This is a photograph of the 1-inch galvanized screw that I removed from Miss Saylor's stomach.
And has the appearance of this photograph been altered in any way since you last saw it?
No, it has not.
At this time, I would like to note to the jury at stipulation 16, which states Exhibit C is the 1-inch galvanized deck screw ingested by Bryson Saylor and subsequently removed by Dr. Cameron Caress.
Any objection, Mr. Driver?
No objections, Your Honor.
I now offer Exhibit C to be entered into evidence and published to the jury.
Offered in Exhibit C. You may continue.
Thank you. Now, will you describe the screw for the jury, Dr. Caress?
Of course. So this screw is a 1-inch galvanized screw, and it is very pointed, as you can see, which led me to conclude that the screw had the capacity to tear Miss Saylor's stomach lining to shreds.
Thank you, timekeeper. So after you removed the screw, did you run any more tests?
Yes, I did. I performed an esophagogastroduodenoscopy, also known as an EGD, to check for any damage to Miss Saylor's stomach lining, as well as Miss Saylor's esophageal lining. These EGDs are invasive, uncomfortable procedures.
What did this EGD show?
From what I could see, there was no permanent physical damage. However, EGDs can be inconclusive. Therefore, there may have been undetected damage, specifically internal bleeding and perforations, yet I may not have been able to pick up on it.
What were your medical reasons for performing this EGD?
To look for any damage, to check for any perforations, lacerations, abrasions, internal bleeding, tears in Miss Saylor's stomach lining, as well as her esophageal lining.
No further questions at this time, Your Honor.
Any cross-exam?
Yes, Your Honor. Good afternoon, Dr. Carez.
Good afternoon.
You work at Poultry Community Hospital, correct?
Yes, I do, and it's been almost 15 years, more than 15 years.
And your job is much beneath your medical pedigree, correct?
One could put it that way, but I do love being a gastroenterologist, and I love interacting with my patients. And I'm here day in and day out.
Thank you, Dr. Carez. You would say your job is much beneath your medical pedigree, correct?
Objection, relevance.
Driver?
Your Honor, it would be relevant to establish Dr. Carez's feelings towards his job, as if he had negative feelings towards his job. We would be able to determine, at least relatively, the level of care that he would normally provide.
May I respond, Your Honor?
Yes, go ahead.
Dr. Carez's personal feelings towards her employment or employer do not make any aspect of this case more or less probable. We are discussing battery today, and her personal feelings with her boss or her work environment do not affect this.
I tend to agree. I'll allow the testimony. Keep going.
So you would say your job is much beneath your medical pedigree, correct?
Sure, but when I say that, I just mean that I'm not really a big fan of the work environment that I'm in. It's not as supportive and friendly as back in New York. But I do love my job, and I love being a gastroenterologist.
Dr. Carez, you said you love your job?
I do. I just don't love the work environment I'm in.
Thank you, Dr. Carez. But you would say this is a crappy job, correct?
When I say that, I mean...
Objection, Your Honor. I apologize for this, but I just wanted to clarify. You said you agreed after I said my part, but you allowed the testimony. I just wanted to make sure I
I'm
understood.
going to let a little leeway here. Again, the relevancy here is minor. I'm not sure why I spent a lot of time on this, but I'm going to give him a little time to explore that. Go ahead.
Thank you.
So, Dr. Cares, you would say that your job is crappy, correct?
The work environment is crappy. I don't like using that word, but that's what I would say. It's not a very supportive or friendly environment.
But Dr. Cares, you have said that this job has ruined your career, correct?
Yeah, one could put it that way, but again, I do love the work that I do. You know, I'm here day in, day out. I see my patients, and then I go home and I come back.
You said that this job ruined your career, correct?
Sure, but again, I still love the work that I do.
Thank you, Dr. Cares. And now you start giving your patients prescriptions when half of them probably just need a Pepto-Bismol and a Sprite, correct?
Well, actually, many of my patients who come to me come with larger digestive issues, and Pepto-Bismol and Sprite, as you just mentioned, are used to treat smaller digestive issues. So any patients who do come to me with these smaller digestive issues, I generally will prescribe them equally beneficial prescriptions just for their digestive problem.
But Dr. Cares, you do this just to keep your patients from whining, correct?
Again, I do this because I am able to prescribe them equally beneficial prescriptions. And yes, sometimes it does keep them from whining. However, sometimes this Sprite and Pepto-Bismol may not fit some of my patients' lifestyles.
But Dr. Cares, you did say that you give your patients prescriptions when they do not need them, correct?
Objection asked and answered.
Nay response.
I'll sustain. You've already asked that, and she's tried to answer. Let's move on.
And you did treat Bryson Saylor on September the 5th of 2019, correct?
I did. She came into the ER on September 5th, 2019.
And Ms. Saylor is a board member to the hospital, correct?
She is. I'm pretty sure, yes.
And she's even donated a lot of money to the hospital, correct?
Objection, relevance.
I'm going to give him a little leeway here. It could go to credibility if you'll move on.
And she's even donated a lot of money to the hospital, correct?
I really don't know how much, but I just know that she is a donor to the hospital.
But you would say that she's donated a lot of money to the hospital, correct?
I guess. I really don't know how much she's donated.
And the removal of that A was an easy procedure, correct?
Easy for me to perform on Miss Saylor, but not easy for the patient. You know, I did have to perform 2 invasive, uncomfortable procedures on Miss Saylor, and Miss Saylor did have a screw in her stomach.
Thank you, Dr. Kriz. And now the ER doctor noted that there was no damage to the teeth or mouth, correct?
Yes, that is correct. And there are many, many factors that explain why there may have not been any damage to Miss Saylor's teeth and mouth and gums. Take the oral mucosa, for instance. The oral mucosa may have acted as a barrier, protecting deeper tissues such as muscle, fat, nerve, even blood supplies from mechanical insult.
That this indicated Bryson did
Objection. I asked my witness to be allowed to finish her answer. She's providing the explanation to the yes or no answer that she did give opposing counsel.
I'll let her finish her answer.
So the oral mucosa may have acted as a barrier, protecting deeper tissues like nerve, fat, muscles, even blood supplies from mechanical insults, such as trauma during chewing. Even the esophageal mucosa may have acted as a similar barrier. And other factors that must be taken into consideration when looking at why there was no damage to Miss Saylor's mouth, teeth, and gums was Miss Saylor drinking a beverage at the time? Sweet tea, lemonade, water, orange juice, you name it. Was Miss Saylor, how much saliva did Miss Saylor have in her mouth at the time?
Thank you, Dr. Cares. And the ER doctor did know that this indicated Bryson Saylor did not bite or chew the screw before swallowing, correct?
Yes, that is a possibility. But that is what that indicates. However, there are those factors that I just mentioned previously.
Dr. Cares, there was no other damage to Bryson Saylor's stomach or esophagus, correct?
So there was no permanent physical damage, yes. However, EGDs can be inconclusive. Therefore, there may have been undetected damage, and I just may not have been able to pick up on it.
But at no point in treating Miss Bryson Saylor did you find any lasting damage, correct?
Well, from what I could see, I cannot find any permanent physical damage. However, this does not mean that there was no damage at one point in time. In fact, let's take my hand, for instance. Let's pretend that this is Miss Saylor's esophagus and my skin is Miss Saylor's esophageal mucosa. My nail can be the screw in this case. If I take it and I run it down, there's a white line for a second. However, in a moment, it disappears. Just like that, in this instance, the screw could have come in contact with Miss Saylor's mouth and gums, teeth, esophageal lining, and her stomach, but would not have caused her any harm.
Dr. Perez, you did state earlier that you treated Ms. Saylor in September of 2019, correct?
Yes, as I mentioned earlier.
And you received a pay raise in October of 2019, correct?
Yeah, I did.
And sometime after you treated her, Ms. Saylor donated specifically to the gastroenterology.
Objection, relevance.
Your Honor.
Yes.
As we went towards earlier, we were just trying to establish potential bias and credibility issues.
Your Honor, may I respond?
Yes.
And may I call constructive bench conference?
Yes.
I anticipate what opposing counsel is trying to bring into evidence is that Bryson Saylor donated a sum of money to the gastroenterology department in the same year that Bryson Saylor was treated by Dr. Perez. However, pursuant to Rule 402 and 403, I do not think that this testimony makes any aspect of this case more or less probable. Furthermore, this testimony is more prejudicial than probative, as there's been no foundation laid to whether this donation happened before September 5th of 2019 or after, so this information could unfairly sway the jury. Also, Dr. Perez did not receive a direct pay raise from this specific donation. There's no foundation laid to whether these were connected or not.
Robert?
Your Honor, I never made any connection between the donation and this pay raise. Additionally, if the opposing counsel would like me to reword it to not include the timing of the donation, I may. However, it is still relevant towards how Dr. Perez would have treated her patient and their possible credibility issues. That does make this relevant.
I'm going to sustain the objection. I think what happened after the fact, the only issue here was her screw and she removed it. The issue is who put it in there. All this other really doesn't have anything to do with anything to me. So I'm going to sustain the objection. If you'll go ahead with your cross, please.
Yes, Your Honor.
And Dr. Cares, you did say earlier that you found no lasting damage to Ms. Saylor, correct?
No permanent physical damage.
No further questions.
Any redirect?
Just one to redirect question, Your Honor. Now, Dr. Perez, is swallowing a screw considered damage itself?
Yes, of course. In this case, I had to, Miss Saylor swallow the screw, there was a screw in her stomach. That is very dangerous, first of all. And then I had to perform 2 invasive, uncomfortable procedures. It's a lot.
No further questions, Your Honor.
You calling this witness, please?
Your Honor, the plaintiff calls Avery Andrews to the stand. Please state your name for the court.
My name is Avery Andrews.
What do you do for a living, Miss Andrews?
I'm a professional gamer. It's my one true passion in life.
Forgive me, Miss Andrews, but what is professional gaming?
Yeah, so I play these video games, of course, but it's kind of like being in the NFL, but I like to call it the National Forte League. I also compete in tournaments and win big money. Not to mention, I do sponsored streams for Bang Energy.
Well, before all these sponsorships and everything, did you ever have to work a different job to make ends meet?
I had to work at Eat More Chicken. I worked the cash register.
Were you working at Eat More Chicken on September 5th, 2019?
Yes, I was.
Well, did anything out of the usual or just unordinary happen that day?
Yeah, apparently someone swallowed a nail from their sandwich.
A nail? Well, could you describe to the jury what the restaurant was like at the time?
Yeah, it was so our lunch rush is usually really busy, but it was way busier than usual and so much more chaotic.
Well, what were you doing while the restaurant was so busy?
Well, I was working the cash register.
Is that your normal job?
Yep, my usual job.
And did you see anyone of note enter the restaurant that day?
Yeah, I saw Bryson Saylor.
Bryson Saylor. So did you take her order then?
No, I didn't.
I thought you said you were working.
Your Honor, improper foundation. We haven't established. Or no, never mind. Sorry, my bad.
Miss Andrews, you were saying Bryson Saylor came in the restaurant. You didn't take her order, but I thought you said you were working the cash register.
Well, I was until boss lady, Drew Jennings, I like to call her boss lady, told me to take a break.
Well, I thought you said the restaurant was busy. She told you to take a break?
Yeah, it was super weird. I mean, it was so busy that we actually needed more people working. I shouldn't have been asked to take a break.
Well, does Ms. Jennings normally take orders?
No, she doesn't. That's why it's so weird.
So she asked you to take a break. What did you do?
I went to the supply closet, catch some Z's, take a little break.
The supply closet. Why'd you go there?
It was dark. It was quiet. Just a nice place to relax.
So did you take a nap?
Yeah, I dozed off for a bit.
You dozed off. When did you wake up?
When I was rudely awoken by these screams and chaos.
What was happening?
Well, someone was screaming about a nail in their sandwich.
So someone was screaming about a nail in the sandwich. What did you do?
I didn't. Well, I went out to see what was going on.
And what did you see next? What did you see happen next?
I saw a sailor leave the restaurant.
Okay, after Miss Sailor left the restaurant, did Drew Jennings have anything to say about it?
Yeah, he said it's time that bully got what she deserved.
Objection, Your Honor, hearsay. This is hearsay because, this is something that we have. It's not that it's not that a witness isn't here, and so we can say this, and it's also not excited utterance, seeing as Bryson Saylor has already left the store, so this is still hearsay.
Your Honor, may I respond?
Sure, Skipper.
I do agree that it is hearsay, but it falls under two hearsay exceptions. I believe opposing counsel anticipated 803.2, which is excited utterance, and I would also say 803.1.2, admission by party opponent. Excited utterance fits here because this is not Bryson Saylor's statement, so it doesn't matter whether Bryson Saylor was still in the restaurant or not. This took place immediately after. Secondly, admission by party opponent, Ms. Andrews is testifying for the plaintiff. Drew Jennings is the defendant, and therefore this qualifies under that exception.
Your Honor, if I may respond. I'm not making the argument that Bryson Saylor is saying this. I'm saying that because Bryson Saylor, which I feel like we could agree on this, was the source of any major uproar in the restaurant, because they've already left, Drew Jennings would no longer be under great amounts of stress, making this no longer an excited utterance. Furthermore, we never said that Bryson Saylor said this. And so you can't bring that in under admission by party opponent, saying as we haven't said it, so you can't use it.
May I clarify, Your Honor?
Yeah, Your Honor, don't we only get...
Well, no, I think I don't see a lot of spending time here.
Okay.
This is clearly a party opponent admission. I mean, she's the defendant in this case. Her employee said, I heard her say this. I mean, that's a party opponent admission. I don't know why we're arguing that. Anyway, let's move forward. I'll overrule the objection.
Yes, Your Honor. So, Ms. Andrews, right as Ms. Saylor was walking out of the restaurant, what did Drew Jennings have to say about all of this?
He said it's time that bully got what she deserved.
Well, when she said this, were you standing near her?
Yeah, I was right next to her. I could hear her crystal clear.
And remind us again, when did Ms. Jennings say this?
Right after Saylor left the restaurant.
Now, Ms. Andrews, how well do you say you would say you know Ms. Jennings?
Well, I've worked at Eat More Chicken. I worked there for a while, and we had multiple interactions. So I'd say I know him pretty well.
And based on your perception and what you know about Ms. Jennings, could you describe the tone she used when she said this? What was her voice like?
It was really harsh. And, now that I look back on it, it's kind of scary. It's like a husk in Forte. It's like a monster. It was just really scary.
Thank you, Ms. Andrews. No further questions at this time, Your Honor.
Cross-examine.
Yes, Your Honor. Hello, Ms. Andrews. How are you doing?
I'm good.
And you were late to work on September 5th, correct?
Yeah, I was. Feel really bad about it.
And you weren't wearing your glasses on this day, were you?
Objection, Your Honor. Relevance?
Your Honor, it's fully relevant to establish Miss Andrews's capabilities of sight today, as it's going to come up later to show that she was impaired. as we're also.
Your Honor, before we get into further proof, I'd ask we call a constructive bench conference so we're out of the jury's hearing.
Okay.
Your Honor, we're later going to establish that she is impaired as she also was lacking sleep. So in addition to that, and it's also going to come up that she couldn't recognize Bryson Saylor when they walked into the restaurant, or they're showing impairment. So the fact that she's not wearing her glasses does become relevant in like our next question.
Have any response, Ms. Skipper?
Yes, Your Honor. Just that to refer you to direct examination, Ms. Andrews did identify Bryson Saylor as being in the line and being in the restaurant, and also stated clearly what she observed that day. She was not impaired, as I would refer to her previous testimony.
Your Honor,
I'll give you a little leeway. You can bring it up. You know, I don't know how glasses would impair her hearing, but anyway, but if you think it's important, I'll give you a little leeway. You can explore it. Go ahead.
Your Honor. So, Miss Andrews, you said you were able to recognize Bryson Saylor when they walked into the restaurant, correct?
No, no, I didn't at first, no, but I saw.
So you were also.
Objection, Your Honor. I asked the witness be allowed to explain when she did recognize Ms. Saylor as she was trying to do.
Your Honor, I was simply asking if they said something or not, and I got the answer to that. And because it was me simply asking if they said something, there's no warrant for explanation because I'm simply asking for what they said. I'm not asking a question about the day's events.
Well, Your Honor, if I may.
Just let her, if you would, Mr. Owen, just allow the witness finish her statement, please.
Yes, Your Honor.
And then ask the next question. Thank you.
I didn't recognize her at first, no, but I did see Saylor leave the restaurant, and I now recognize her as Bryson Saylor.
And you were, quote, so sleepy on this day, September 5th.
Objection, Your Honor. This is an improper impeachment. Opposing counsel is referencing my witness's statement, though she has not contradicted it. And so he's bringing a hearsay statement in as evidence.
Your Honor, I'm not doing that. I'm simply referencing something she said in the affidavit.
Exactly, Your Honor.
Which is
I think it's proper area for cross-examination. We have open cross-examination, and I think he can ask her. He's going to be stuck with her answer, but but he can ask her. All right.
Thank you, Your Honor.
Go ahead.
And you were, quote, so sleepy on September 5th, correct?
Yeah, I was sleepy. I mean, I was on fire last night from the night before from my tournament. I wasn't gonna sleep.
Thank you, Ms. Andrews. So using a relatively common use of the word impairment, a fairly simple definition, would you say that due to the fact that you were lacking glasses and also lacking sleep, that you were at least partially impaired?
Well, I didn't have my glasses, but you see, I use my glasses for gaming because, that's my job. But like without my glasses, I'm not necessarily blind. And when I am sleepy, I mean, look, when you're sleeping, you can still hear your alarm. That never impairs your hearing.
Your Honor, under Rule 40, this witness is non-responsive. I asked if they were at least partially impaired, and they danced around the question without answering.
Your Honor, may I respond to that?
Yes.
I do believe the question calls for an opinion that this witness probably cannot give as a lay witness the definition of impairment. She has explained how she was affected by the glasses and by the sleep, and so I believe it'd be best to just move on.
Your Honor, we're simply asking for this witness to synthesize the information that they've already put out there. And so under this, it's not asking for any expert testimony. We're simply asking for them to use a common sense definition, which would be allowed under a basic assumption. Or not assumption, but
well, I guess again, I thought she answered the question.
Your Honor,
she didn't have her glasses, but she only used them when she games. So, but I'm not sure. And she says she was tired. I'm not sure what else you wanted to say. But whether or not she can admit that she's impaired or not, I guess she can. Again, you can ask her. She can either say yes or no.
Your Honor, may I explain what I was trying to say? Or do you want me to just move on?
Well, I think we're using a lot of time here on something that's really, I don't think all that important. But if you think it is, question on it. But again, we're trying to cut these objections down because of our time frame here. So we're wasting a lot of time here on this.
Yes, Your Honor. Ms. Andrews, you were written up on September 5th because you're late for the third day in a row, correct?
Yeah, it's kind of embarrassing. I don't really like to talk about it, but yeah.
And you had a disagreement with your manager sometime after September 5th, correct?
Oh yeah, me and boss lady Drew, we did have a disagreement, but we're all good now.
And you now no longer work at Eat More Chicken, correct?
No, I don't. I've decided to pursue professional gaming.
So, Ms. Andrews, you're testifying against your previous management who you no longer work for after having a disagreement?
Yeah, but we're good. It was all professional. I mean, yeah, I am, but I mean, my main reason is like, I mean, like, we're all good now.
Ms. Andrews, did you just say that this disagreement, all your disagreements with Eat More Chicken employees were fully professional?
No, it was a professional agreement. I have nothing against Drew.
So you called Ryan French, the manager at Eat More Chicken, Frenchie before, correct? That's your nickname for him?
Yeah, Frenchie.
And you say that Frenchie is out to get you, correct?
Yeah, I mean, he doesn't really seem to like me.
And you say that Frenchie always makes you sick, correct?
Yeah, I mean.
So would you say that that still sounds like a professional disagreement?
Objection, Your Honor. Opposing counsel was previously asking about her relationship with Ms. Jennings, which I do understand the relevance of, but her relationship with another employee who's not a party to this case and actually isn't going to be called or is later going to be called as a witness is, I see your hand, Mr. Overton, just 1 second, sorry. This is not about her bias towards or against Ms. French. This is about any kind of disagreement or relationship she has with Ms. Jennings, and I believe we're wasting time, the jury's time, with this evidence.
Your Honor, if I may respond.
Yes. Briefly, please.
If we're establishing bias towards against Eat More Chicken from Avery Andrews' perspective, and we're doing this because in her affidavit she says that Avery Andrews is always sucking up to Drew, or sorry, she later goes on to somewhat equate Ryan French and Drew Jennings, and so by establishing bias against Ryan French, we're also somewhat establishing bias against Bryson Saylor, and in general, we're also establishing bias against her own workplace or former workplace.
If I may, Your Honor,
Yes.
Eat More Chicken is not a party to this lawsuit, and neither is Ryan French. And she does not equate Ryan French and Drew Jennings. Drew Jennings is the party to this lawsuit, and we have covered her relationship with Drew Jennings.
I agree with Ms. Skipper. I'll sustain the objection. Let's move on.
Yes, Your Honor. And so you'd say that in general, you and Drew didn't tend to get along the best necessarily, correct? Just a workplace thing?
I mean, I was late quite often, and I was ashamed of it. So, I mean, like, he obviously wouldn't be happy because he was my boss, but I'd say like it was maybe one-sided, but it's totally understandable. I mean, I have nothing against Drew.
And going back to your glasses on the morning of September 5th, did you break them?
Can you say that again?
Going back to your glasses on September 5th, would you say that it's fair to say that you slammed them on the counter that morning?
I did. I didn't do too well in my 4th day tournament. I thought I was going to win and I barely lose. So it just hit different.
Thank you, Ms. Andrews. And right after this, you went to work at your job, Eat More Chicken, on September 5th?
Yes, I did that morning.
The same job that you have had disagreements with their management for?
Yes, but
no further questions.
I'm on good terms with.
Well, I said.
All right. Thank you. All right.
Your Honor.
Any redirect?
Plaintiff has no need for redirect, Your Honor. Thank you.
Call next witness, please, or is there any other?
No, Your Honor. The plaintiff rests our case in chief.
Defense like to call any witnesses?
Your Honor, at this point, we would like to call Drew Jennings to the stand. Hold on, I might have just gone out of the order. Your Honor, may I check quickly?
Okay.
Okay, never mind, Your Honor. I did not go out of order. All right.
Okay.
Sorry.
Go on.
Sorry, I just realized I've been muted for a while. Please state your name for the court.
My name is Drew Jennings.
And where are you from, Ms. Jennings?
I've been a lifelong resident of Poultry County. I lived here from the time when I was born till after I graduated high school.
And did you receive education after high school?
Yes, I left Poultry to attend the University of Volunteers on a scholarship.
And what do you do for a living, Ms. Jennings?
I am the owner of Poultry's local Eat More Chicken franchise. When I was in college, I worked as a manager at Eat More Chicken, which I ended up really loving. And so once I came home after I completed my studies, I decided to open up a business of my own.
And how has your business been?
My business has been doing really well. On opening day, we sold out a chicken within 5 hours, and it's even been said on social media that poultry is the new king of the the Eat More Chicken is the new king of the chicken sandwich here in Poultry.
Do you recall what you were doing on September 5th, 2019?
Yes, I was working at my restaurant.
What were you doing around lunchtime on this day?
Around lunchtime, I was fixing some pictures that had fallen off the wall near the restrooms.
And Ms. Jennings, did you do anything else during the lunch hours?
Well, as I was fixing the pictures, my manager, Ryan French, came up to me and informed me that Bryson Saylor was in line at my restaurant, so I went over to check it out.
And why would it be important for you to know this information?
Well, it was important for me to know so that I could give so that I could give Bryson Saylor the best service.
And how did you proceed after you knew Bryson was in line?
Well, I went over to the register to take his order.
And did you take Bryson's order?
Yes, Bryson ordered a regular chicken sandwich with some fries and a sweet tea.
Did you have time to finish hanging the pictures before you took their order?
No. In my rush to get to the register, I didn't even have time to put my toolbox back in my office.
And what did Bryson Saylor order?
She ordered a regular chicken sandwich with fries and a sweet tea.
Is there a protocol that employees must follow before serving?
Yes. At Eat More Chicken, employees are supposed to check the order to make sure it's correct before they deliver it.
And Ms. Jennings, did you follow this protocol?
Yes, of course.
Ms. Jennings, who delivered Bryson Saylor's food?
I did. As I was approaching Bryson's table, I remembered that a really big crowd of customers and protesters were surrounding me because the protesters had all started chanting. So I set the tray down on a nearby table so that the crowd wouldn't make me drop it.
And where did you go after setting the tray down?
After I set the tray down, I walked back to the register to get some napkins.
Would you have seen if anyone touched the sandwich while you were away from it?
No, I don't believe I would have.
And when you returned, did you notice anything strange?
Well, I did notice that when I got back to the sandwich, the top bun had slid to the side, which was weird, but I fixed the presentation and gave Bryson their order.
And what did you do after you delivered the order?
Well, I was starting to walk back to finish, go back to work when I heard a commotion coming from the area where Bryson was seated.
And did you approach Bryson Saylor?
Yes, I did. As I walked to the area, my manager, Ryan French, was with Bryson offering to call 911, but Bryson refused to wait for an ambulance.
Miss Jennings, what happened when you got to the table?
I just wanted to calm the situation, so I offered to drive Bryson to the hospital myself. But Bryson refused and kept yelling that eating at my restaurant was dangerous.
And what happened after you spoke to Bryson?
After I spoke to Bryson, they just stumbled out of the restaurant.
Do you know how Bryson Saylor may have swallowed a screw?
No, I don't.
And did you place the screw in Bryson Saylor's chicken sandwich?
Of course not. I have worked so hard to build myself a stable career and a stable future in the job that I love. And I have that now. So why would I jeopardize that over something as silly as a business rivalry, which I was using to drum up business for my own restaurant anyways? That would be just stupid and wrong.
Thank you, Ms. Jennings. No further questions, Your Honor.
All right, cross-examine.
Good afternoon, Ms. Jennings. My name is Ria Patel, and I just have a few questions for you today.
Okay.
So you and Bryson Saylor aren't the best of friends, are you?
Well, I didn't really know her personally, but I did know that we were competitors in the same small town, so I guess not.
But this hasn't stopped you from making opinions about her, has it?
Sorry?
This hasn't stopped you from making opinions about her, has it?
Well, I suppose everyone makes opinions about people they don't know.
Now, Ms. Jennings, you think Bryson Saylor is a shady person, don't you?
Bryson definitely has done some things in poultry to earn that reputation, so yes.
And you think that she's ruthless, do you not?
As I said, she's definitely done some things to earn quite the reputation, so I would suppose so.
And that's why moments after Bryson Saylor left your restaurant, your first words were, "I hope Bryson's okay, even if others say that bully got what she deserved," right?
Well, I know others, especially, it's not just me, who don't have a great opinion of Bryson. I hope that she was okay, of course, but yes, I suppose I did say this.
So I want to look at the back end of that statement. At this time, I would just like to mention and remind the courts that witnesses are not allowed to use notes. Just a reminder. And so I really want to look at the last part of that statement when you say, even if others say that bully got what she deserved. Now, you said that others say that, but who were those other people?
Well, I suppose just others who lived in poultry. I mean, it is a small town, so we do know each other.
So it's your statement today that other people came to you and told you that Bryson Saylor got what she deserved by swallowing a screw.
Well, I never said that, other people had told me, but I mean, it's something you hear in general conversation around small town. I'm sure it's come up in conversation a few times.
But Ms. Jennings, you would agree with me that Bryson Saylor had just left your store screaming just moments before about swallowing something, correct?
She said she thought she had swallowed a nail. Yes.
She had left just moments before, right?
Well, yes.
So in that time frame of her leaving and you saying this statement, who came to you and told you that Bryson Saylor got what she deserved?
Your Honor, this is an unfair extrapolation. In the affidavit, it says even if other people might say this, it's not saying that other people did say this. So my opposing counsel saying that some people actually came and told Ms. Jennings that this happened is an unfair extrapolation because it says might.
Your Honor, if I may respond, the witness
Yes.
has full discretion to say that no one actually told her this, if no one actually told her and this was just her own thought about what other people might say.
I'll give her a little leeway here if you'll go on. May continue.
So no one actually came to you and told you that Bryson Saylor got what she deserved.
Well, I would say, it's a fair assumption to make based on what I do know of the opinions of others around me. I mean, as a business owner,
I'm gonna have to ask you for a yes or no answer. No one actually came to you and told you that Bryson Saylor got what she deserved.
I suppose not.
And then also I want to talk about that last part of the statement, got what she deserved. Now, according to you, what did Bryson Saylor deserve in that moment?
Well, I never actually said it was my opinion. I said other people might think this based on what I know of the people who I work with every day and my customers who I see every day. So I would assume that they were referring to the harsh, her reputation that she has in poultry and the fact that she did swallow a nail, but I personally didn't have any ill will towards her.
So it's your statement today that you said might get what she deserved, correct? Even if other people might think she got what she deserved. Is that your statement today?
I would say my statement would be, I hope she's okay, even if other people might think that she got what she deserved. Yes.
Do you remember giving a statement in this case, Ms. Jennings?
More or less. It was quite a while ago, but I have, reviewed my affidavit, so I'm fairly familiar with it.
And would you recognize it if I showed it to you today?
Yes, definitely.
And you would agree that you made this statement closer to the events in question than today is?
I would like to see the statement before I can attest to that, but if you would show me, then I will give my opinion.
Of course. Timekeeper, can you please share Ms. Drew Jennings' statement? Is this your statement, Ms. Jennings?
Yes, this is my affidavit.
And is it accurate?
Yes.
And it was made closer to the events in question than today is, correct?
This is correct.
Now, Timekeeper, can you please move the statement to the second to last paragraph? And I'm really focusing in on that last line where it says, when Bryson made his order and saying, I hope Bryson is okay, even if people think she is a bully and got what she deserved. Now, does that statement say the word might in it? Ms. Jennings?
No, it doesn't.
Okay, thank you. So now I want to talk a little bit about those direct messages that you shared with Ms. Bryson Saylor. Timekeeper, can you please share Exhibit D or slide 12? Thank you. Now, Ms. Jennings, this is your direct message with Bryson Saylor, correct?
Correct.
And your messages are in the gray on the left side of the screen, right?
Yes, this is correct.
Now let's discuss how you finished this conversation. So your words were going to enjoy watching your chicken kingdom crumble, correct?
Yes.
So you predicted that Bryson Saylor's chicken kingdom would crumble, correct?
Well, I was aware that my business was doing well, more so than hers. So I guess that would be a prediction, but it wasn't made in malice, of course. I mean, as I stated earlier, I was just using at the time the rivalry to drum up attention for my own business, as social media is a very good marketing tool.
And not only did you predict that her chicken kingdom would crumble, you were going to enjoy watching it happen, weren't you?
Well, only in the sense that it would make my sales do better. I wasn't enjoying watching other people fail, of course, but if my business does better, that's just the way it works.
And now I want you to look at the date below that message. It says September 4th, correct?
Correct.
So this message was made the day before a screw was found in Bryson Saylor's stomach, correct?
Yes.
Now, thank you, Timekeeper. Now I want to turn our focus to September 5th. When Bryson reached the register, you wanted to be the one to take her order, correct?
So as I stated, I wanted to make sure Bryson had the best service. So yes, I did want to be the one.
And you were so in a rush, so intent to take her order that you didn't even have time to put away that toolbox you were carrying, did you?
Well, it is a fast food restaurant, and so the line does, of course, move fast. So I wanted to make sure that I was the one to serve, and no, I didn't have time to put my toolbox away.
Now, Ms. Jennings, I just want to make sure you're aware of the allegations being held against you. You're aware that both of the parties have stipulated that a 1-inch galvanized screw was removed from Miss Saylor's stomach by Dr. Caress, yes?
At this point, yes, very.
And you're also aware that both of the parties have stipulated that your toolbox, the one that you had near that register, didn't have time to put away, also contained a ACE number 6 Phillips bugle head 1-inch galvanized screw, right?
Yes.
Now, when you got to the register, you told the cashier to take a break, correct?
This is correct.
So this would mean that that cashier was nowhere near what you were doing at that register, right?
Well, since I wanted to serve Bryson their order, it didn't really make sense to have the cashier standing around. So I wouldn't say that it was that I wanted her to go away. I mean, there was plenty of other people around to watch, what has been alleged against me if I were to have actually put the screw in the sandwich. It's not that that would have been without any potential witnesses.
Right. So, but if you were, I don't know, say to do something to that sandwich, open it up, look at it, turn it around, that cashier would not be there to see you do it, right?
Objection, Your Honor. Outside personal knowledge, this witness does not know where the cashier went, only that they told them to take a break. They did not follow the cashier.
Your Honor, may I respond?
Yes.
This question is based on the rational perception of the witness. She would know that as she was the one that dismissed the cashier to go away into a different part of the restaurant, that the cashier was no longer around her and would not be able to see what she was doing with her food.
Your Honor, if I may respond.
Okay.
This witness, again, simply told the cashier that they could take a break. They did not say that they should go to a certain part of the restaurant. And Ms. Jennings, in order to serve Bryson Saylor, did not follow this cashier around. And so they cannot state if they could see it or not because they don't know where they went. So this is, again, outside scope of personal knowledge.
It's a stated objection. I think unless you can establish she knew where the employee went, she doesn't know what the employee saw or did not or could have, or so I'll sustain the objection.
Yes, Your Honor. So on your way to deliver that sandwich to Miss Saylor, you realized you forgot napkins, correct?
Yes, this is correct.
So you had to go back to the register area and come back to the sandwich before you realized it looked a little off to you, right?
Well, yes, I did have to leave the sandwich in the crowd to go get the napkins because I didn't want to drop it. So when I came back, the top bun had moved, so I fixed it.
And at this point, you didn't think to, I don't know, get Miss Saylor another sandwich, did you?
Well, I didn't see any reason to at the time.
Right, but you did see a reason to touch that sandwich and adjust it, right?
Well, it's not like the sandwich had flipped over or was on the ground. It was only that it slightly moved. And since I wanted to make sure the presentation was perfect, I just fixed it. I didn't think much of it at the time.
So yes, you did touch that sandwich when you came back from the register area.
Objection, Your Honor, asked and answered. This witness said yes, that they did touch it after they came back on the last question.
Let's just move on, Ms. Patel.
Yes, Your Honor. And you delivered that sandwich after you touched it, correct?
Yes.
So in between the time that you got that sandwich from the cooks in the back and the time that you gave it to Miss Saylor, you didn't see anyone else touch that sandwich besides you, correct?
I didn't see anyone else, but I did leave it unattended.
So that's a yes, you did not see anyone else.
As I just stated, I didn't see anyone else.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor.
All right.
Miss Jennings, would you ever put a screw in somebody's sandwich?
Of course not. Not especially not for a reason like this.
Thank you, Miss Jennings. No further questions.
All right. Call next witness, please.
Yes, Your Honor. We'd like to call Taylor Tarr to the stand. Please state your name for the court.
My name is Taylor Tarr.
And Miss Tarr, what do you do for a living?
I'm an accountant.
Have you been an accountant all of your life?
Well, not my entire life. Mom always said I'd pipes like a dream. So for a while, I had all these plans of hitting it big as a country star. Played at a few honky-tonks on Broadway to put myself through college, though I have to admit, I'm a nerd at heart. And while I was in college, I realized my true passion was for accounting.
And how long have you been an accountant for?
Since I graduated with my master's.
Miss Tarr, how long have you been in poultry?
Why, I've lived in poultry for almost all of my 34 years, except when I had to leave to go to Bruin University in Nashville. But soon as I graduated, I came right on home. My family's been in town for 7 generations, you know. Couldn't just leave poultry behind.
And do you know Miss Saylor?
I work as the primary accountant for Sailorman's, which is run by Miss Saylor.
And how long have you worked with Miss Saylor for?
A few years now.
Did you happen to see Miss Saylor on September 5th, 2019?
Yes, I did.
And why were you with Miss Saylor that day?
We were having a meeting to discuss the financial health of the company.
And what did you present to Miss Saylor?
We went over the company's financials for the month of August.
Miss Tarr, how is the business doing?
Oh, sales were down substantially from last year.
And was this what your meeting was about?
Yes.
And after you met, how did Bryson respond?
Well, after I told Bryson, she got on the phone yelling at someone else. Then she stormed out of the office.
And how did you feel as a result of Miss Saylor's actions after the discussion?
Objection relevance. How this witness feels to Miss Saylor has nothing to do with the case at hand today of whether or not Drew Jennings put a screw in Bryson Saylor's sandwich.
Your Honor, how this witness feels as Miss Saylor's accountant, and was able saw Miss Saylor on the day of the incident is totally relevant to establish Miss Saylor's, I suppose, mood that day.
I'm gonna give you a little leeway here. I'll overrule the objection. You can continue.
Thank you. I'll repeat the question, Ms. Tarr. How did you feel as a result of Miss Saylor's actions after the discussion?
Well, I felt scared after the meeting, as I have been many times when working for Bryson.
And after the meeting, what did you do?
I still had a few reports that I needed to put on Bryson's desk, so that's exactly what I did.
And did you happen to notice anything odd on her desk?
Yes, yes. I saw a box filled with little thingamajigs, nails, push pins that had been overturned on her desk. I also noticed her computer screen where she was having a conversation with someone called at no one chicken fan one, but I couldn't make out what they were saying.
No further questions, Your Honor.
Cross-exam?
Yes, Your Honor. Good afternoon, Ms. Tar. My name is Sonia Shrivastava, and I'll just be asking you some questions today.
All right.
You've worked with Bryson Saylor for a long time as her accountant, right?
I've been her accountant for a few years now, yes.
So you're pretty familiar with her business, Sailorman's.
Oh, definitely. I'm the primary accountant for her business.
So you see all of her financials?
As an accountant, that is part of my job, yes.
You even see how much she pays those who are loyal to her, don't you?
Yes, I can see that.
And you consider yourself loyal to Miss Saylor, right?
Of course, I would consider myself a great accountant.
But you haven't gotten paid your fair share for this loyalty, have you?
Well, Bryson has paid me sufficiently for being an accountant.
But you've never gotten a bonus?
I've never received a bonus, no, just my usual paycheck.
Now, let's turn our attention to September 5th. You met with Miss Saylor that morning about her financials, right?
For the month of August, yes.
And these financials were down by 25%.
Yes, I was actually worried how Bryson was going to respond to that. She's a bit of a loose cannon.
Now, Miss Tar, correct me if I'm wrong, but Miss Saylor's primary source of income is her business, right?
Yes.
So it's understandable that she was upset seeing that her business was down, right?
Oh, well, of course. I just was worried she would get really upset or angry or something, which of course is understandable.
Now, Miss Tar, you met with Miss Saylor in your office on September 5th, right?
Yes, that's correct.
And you had testified that Miss Saylor stormed out of your office, didn't she?
That was where we were having the meeting.
She didn't storm out of her office.
No, as I said, the affidavit is a little wordy, tricky with the, language. My office, her office, stuff like that.
Right, but Miss Saylor did not storm out of her office, right?
She stormed out of the office where we were having a meeting.
And you also testified that you saw some metal things on Miss Saylor's desk, right?
There was an assortment of all little knickknacks and stuff. I'm not an expert by any means. It really could have been anything.
But you saw nails and push pins, right?
That among other things, yes.
And while you were searching through these metal things on Miss Saylor's desk,
Objection, Your Honor, improper foundation. The opposing counsel hasn't laid the foundation for saying that Ms. Tar was searching through the stuff on the desk. Ms. Tar has only established that she has noticed what was on the desk, just random things. Obviously, she didn't get a good look at it.
Your Honor, I can rephrase my question.
I'll allow you to rephrase the question.
So, Ms. Tar, while you were looking at these metal things on Miss Saylor's desk, you didn't see a screw, right?
Well, I didn't spend any particular amount of time taking note of what was on her desk. Just a quick glance while I was putting my reports on the desk.
Ms. Tar, yes or no, while you were looking at the things on Miss Saylor's desk, you did not see a screw?
Not in particular, no.
And after Miss Saylor left the office, you didn't know where she was going.
That is why I decided to look at her computer screen. She had stormed out after yelling at someone on the phone, and I thought maybe I could get a clue as to where she had gone. I only happened to see, though, who she was talking to.
Ms. Tar, let me redirect you back to my question. You didn't know where Miss Saylor was going, yes or no?
No.
In fact, you didn't even know what Miss Saylor was planning on doing with her day.
No, we only had the meeting.
And Ms. Tar, on September 5th, 2019, you weren't at Eat More Chicken, were you?
That day, no.
So you didn't see Drew Jennings serve a chicken sandwich to Miss Saylor?
Well, I wasn't at the restaurant, so no.
Right, so you didn't even see Miss Saylor swallow a screw after she received her order from Drew Jennings?
Of course not. I'm just her accountant.
Right, so Miss Tar, You have no personal knowledge of the battery that took place at Eat More Chicken on September 5th, 2019, do you?
Why would I? No, I don't. Not at the restaurant.
Thank you, Your Honor. No further questions.
Any further witnesses?
Yes, Your Honor. We'd like to call Ryan French to the stand.
French?
Please state your name for the court.
Ryan French.
Mr. French, what do you do for a living?
I am the manager at Eat More Chicken in Poultry, Tennessee.
And who is your employer?
I was hired by Drew Jennings.
So how has Eat More Chicken's business been?
Our business has been doing really, really well.
And were you working at Eat More Chicken on September the 5th of 2019?
Yes, I was.
And do you recall who else was working that day?
Yes. I remember that Avery Andrews was also working on that day. Oh, and Drew Jennings, of course.
And who is Avery Andrews?
Avery is one of the employees we hired after the location in Poultry opened, and we realized we're understaffed. She's always late.
And do you remember the day of September the 5th at the restaurant?
Yes, I do. We had some protesters coming in during our lunch rush, which is unusual. And the weird thing is, all of the protesters were wearing chicken costumes and chanting and holding up signs. I remember they just wanted to keep them from bothering our customers, though.
So what did you do anything about these protesters?
Yes. As the manager, I went up to the protesters and respectfully asked them to not crowd the entrance so our customers could get through. They complied, which I was glad about, but I do remember one of the protesters walking into the restaurant at the time.
So what did you do next?
Objection. Council has a lot of leeway to discuss protesters. However, this is not relevant to the case at hand, which is the case of whether or not Drew Jennings committed battery. In addition to this lack of relevance, Stipulation 7 provides that no criminal assertion of criminal fault or any defense can be raised against any non-party in the case. And that's, I believe, what is trying to occur here with mention of the protesters.
Mr. Driver?
Your Honor, we are just laying a foundation for what Ryan French did that day.
I'm gonna give him a little leeway here, Ms. Skipper. He can say what he saw or what he experienced. Okay, go ahead.
So what did you decide to do next, Mr. French?
Well, after I talked with the protesters, I went back behind the register to help out with the lunch rush. And that's when I happened to see Bryson Saylor.
Did you recognize Bryson Saylor?
Yes, I recognized Bryson when he walked in, since at the time he was on a lot of TV commercials.
And around when did Bryson come into the restaurant?
I believe it was during lunch.
So what did you do when you saw Bryson?
I went to get my boss, Drew Jennings.
And where was Drew when you told him this?
Drew had actually just came back from a corporate meeting and was hard at work fixing a sign that had fallen down near the restroom.
Why would you tell Drew that Bryson was there?
Well, you see, Bryson is our competitor, and at the time he was at our restaurant, so I thought Drew would like to know about it.
And did you see the protesters the rest of the day?
After I talked with them, I didn't really pay attention to the protesters at all, so they could have been there, but I wouldn't know about it.
And did you happen to see how Bryson Saylor swallowed the object?
No, I did not. I was wiping down some dirty tables to make more room for the customers when I heard someone screaming about swallowing a nail. I ran over and saw it was Bryson Saylor. I offered to call 911 for Bryson, and Drew came over and even offered to personally drive him to the ER, but Bryson just walked out of the restaurant.
No further questions, Your Honor.
Any cross-exam?
Yes, Your Honor. Good afternoon, Mr. French. My name is Anthony Skipper. I've got a few more questions for you today.
Good afternoon. It's nice to meet you.
You as well. Now, Mr. French, you're a big fan of Drew Jennings, right?
Well, I wouldn't say I'm a big fan. I would just say I respect him as a successful businesswoman.
Well, you even asked for Ms. Jennings' autograph the first time you met her, right?
Well, at the time, Drew had been named Regional Chicken Woman of the Year and was featured in Southern Fried Business magazine. And so I thought it would be cool to personally have her sign the magazine she was featured in.
You really want to follow in Ms. Jennings' footsteps one day, don't you?
Well, I'd like to think that I want to follow in the footsteps of a great businesswoman, since later on in life, I also want to become a successful businessman. So I do like to think I'm following her footsteps.
So she's a bit of a role model for you then, huh?
Well, I wouldn't say role model, but she's what I want to become later in life as a businessman.
Now, you also are aware that Drew Jennings is the defendant in this case, right?
Yes.
And you're aware that the defense attorneys have been the ones to request that you testify here in court today?
Yes, I believe so.
Now, I want to focus on the day in question, September 5th, 2019. Just that morning, Ms. Jennings had gotten angry at Avery Andrews, right?
Well, I wouldn't say Drew Jennings got angry. Drew wrote Avery up because Avery was late 4 days in a row and didn't really apologize about it. I wouldn't really call that, I'm sorry.
That's okay, Mr. French, we will move on. So there was some sort of disagreement or confrontation between Ms. Jennings and an employee that very morning?
I didn't see any confrontation. All I remember was Drew writing Avery up about it and Avery getting angry about it. I wouldn't really call it a confrontation.
Right, and also that day, Eat More Chicken was understaffed, wasn't it?
Yes, we had a lot of customers lining outside the door, and well, Avery was 1 hour late on that day, and during a lunch hour rush, we were very understaffed.
And where was Ms. Jennings the whole time while the restaurant was so busy?
Well, Drew had actually just came back from a corporate meeting and was hanging up signs around the store that advertised a new product, the sweet potato spice coffee.
And Mr. French, let me get this straight. Ms. Jennings was not taking orders at the register that day?
I don't believe he was, but I'm not sure.
But Ms. Jennings did begin taking orders right when Ms. Saylor got to the front of the line, right?
Actually, I don't remember Drew taking orders at all. All I remember was Drew hanging up signs around the store, and after that, I was focused on doing my job, and I was not really aware where Drew was the rest of the day.
So it's not true that Drew Jennings insisted on serving Bryson herself?
When I went to tell Drew about Bryson, while Drew did say she wanted to serve Bryson, I'm not sure if she actually found the time to or not. Drew is the boss for this location in Poultry, and she's a very busy woman, so I'm not sure if she actually got to serve Bryson or not.
Mr. French, let's stick more closely to my question.
Okay, I'm sorry.
Ms. Jennings did say that she did not want anyone else but herself serving Bryson Saylor, right?
Well, she did say that. I'm not sure if she actually served Bryson or not.
That's okay, Mr. French, that wasn't my question. Now, when you found Ms. Jennings, she was fixing a sign, you said?
You mean why I told her about Bryson?
Yes.
Oh, yes. She was fixing up a sign that found down near the restroom.
And again, she said that she wanted to serve Ms. Saylor personally. That's what she said?
Yes, she did say that.
And I want to talk about also what you heard in the restaurant after that. You said you heard someone, Ms. Saylor, screaming about swallowing a nail. Is that right?
Yes, that is correct.
Just to clarify, Mr. French, that was a nail and not a screw?
I think it was a nail. I remember hearing about a nail, but at the time I was focused on wiping down tables and wasn't really sure about it.
So a yes or no would be helpful, Mr. French. Yes or no, you heard Ms. Saylor screaming about swallowing a nail, not a screw.
At the time I thought I heard it.
Is that a yes to my question then?
Oh, yes.
Thank you, Mr. French. No further questions this time. Thank you, Your Honor.
Any cross-exam?
We do not have a redirect, Your Honor.
Oh, you don't want to, okay. You have nothing back. All right. Anything else from the defense?
No, Your Honor. The defense rests.
Either part like a closing statement?
Yes, Your Honor. Before I begin, I would just like to ask that up to 1 minute of my remaining time be reserved for my rebuttal.
Okay.
Thank you. May it please the court. You have now heard all of the proof. On September 5th of 2019, Bryson Saylor walked into an Eat More Chicken restaurant to try the competitor's chicken sandwich. She took a bite. Suddenly, she felt something sharp slide down her throat. Feeling unsafe, she left for the emergency room as fast as possible, where she was then seen by Dr. Cameron Carez, who emergently performed an endoscopic foreign body removal, retrieving a 1-inch galvanized metal screw from our client's stomach. Today, the proof has shown that someone had access to a screw, access to a sandwich, a reason, and an opportunity to harm my client, and that could only be Drew Jennings. Before September 5th, Ms. Jennings, through her Twitter alias @1chickenfan1, went after Saylor's business with unethical, slanderous attacks. Hiding behind her Twitter handle, Jennings threatened Saylor personally, asserting, "Going to enjoy watching your chicken kingdom crumble." And then Ms. Jennings herself admitted on Cross Today that if Bryson's kingdom crumbled, she would have more customers, a clear motive. And the very next day, Jennings turned those malicious words into action. Ladies and gentlemen, Drew Jennings had the intent, means, and opportunity to put a screw in my client's sandwich. Jennings has stipulated that her toolbox at Eat More Chicken contained a screw identical to the one found in Miss Saylor's stomach. Furthermore, she pushed the cashier out of the way to take Miss Saylor's order, effectively getting a potential witness to her act out of the way. She then told you she put the sandwich down on the table under the ruse of getting napkins. We submit to you that Jennings did this to claim plausible deniability, an opportunity to blame the act on someone else. Finally, Jennings admitted that she touched the sandwich when she came back from the register area and before she delivered it to Miss Saylor herself. Now, members of the jury, I want us to think about what Drew Jennings said right after my client swallowed the screw. Ms. Jennings wasn't surprised. In fact, some of her first words were that Bryson got what she deserved. Not, "I wonder what happened," or "let me go check on her." When Bryson left Jennings' restaurant screaming in pain, some of Drew's first words were that bully got what she deserved. Words that hope for the absolute worst for my client, words that reflected her actions. These words indicate that Drew Jennings knew exactly what had happened to Miss Saylor. And why? Because she put the screw in the sandwich herself. When Drew Jennings turned her words into action, she committed a battery. The tort of battery requires the intent to perform an act that causes offensive physical contact to another person. In this trial, the intentional act of placing a screw in my client's sandwich caused the offensive physical contact. And furthermore, as a result from swallowing this screw, Ms. Saylor had to undergo 2 uncomfortable, invasive procedures, further increasing the offensive physical contact she experienced. As the plaintiff, we had to prove to you that it is more likely than not that Drew Jennings put a screw in my client's sandwich, and there is both direct and circumstantial evidence to prove it. Members of the jury, there are rules of engagement that are appropriate for business, but Jennings stepped over those boundaries when she turned her words into action. The defense claims that Bryson Saylor carefully put the screw in her throat. However, it is simply unreasonable to assume that an educated, successful businesswoman like Ms. Saylor would purposely hurt herself to prove a point. Rather, we submit to you that Jennings carefully placed a screw in Ms. Saylor's sandwich and believed that Saylor got what she deserved. We, the plaintiff, have met our burden. It is more likely than not that Drew Jennings committed the tort of battery against Bryson Saylor. We ask that you render a verdict in favor of the plaintiff. Thank you.
Defense like a close?
Yes, Your Honor. May we begin?
Yes.
Thank you. May it please the court. Your Honor, ladies and gentlemen of the jury, Drew Jennings has been falsely accused of battery today. I'll remind you that battery requires the plaintiff to prove 3 things. The first is contact, that Drew Jennings placed the screw in Bryson Saylor's sandwich. And the second is intent, that Drew Jennings placed the screw in the sandwich with intent to harm Bryson Saylor. And the third is actual harm, that Bryson Saylor was harmed as a result of Drew's supposed actions. Additionally, the plaintiff needs to prove all 3 of these with a preponderance of evidence. So if there is any doubt in your mind that any one of these 3 criteria aren't met, then the jury needs to rule in favor of Drew Jennings. Our case against this is clear and obvious and is only furthered by the witnesses that we called to the stand. The first witness that we called was Drew Jennings. Drew testified under oath that she does not know where the screw came from, despite delivering Bryson's sandwich. Drew Jennings is a good woman who would never jeopardize her business, her career, and her life by putting a screw in Bryson Saylor's sandwich. As my opposing counsel said, she had some words to say after Bryson Saylor left her restaurant, but they were not the words that my opposing counsel said that she said. In fact, her first words after Bryson Saylor left the restaurant were that she hoped Bryson Saylor was okay. That does not sound like the voice of somebody who put a screw in a sandwich. That's not remotely close to what someone who would do such a heinous act would sound like. The second witness that we called was Taylor Tarr, Bryson Saylor's accountant, who saw Miss Saylor that day. She saw a box that was overturned on Bryson's desk, filled with screws, nails, and push pins. That, right now, should be enough to inspire a seed of doubt in your mind, right there. They have given you no concrete evidence of Drew Jennings committing this act. Taylor Tarr saw Bryson Saylor leave her office in an angry hurry and go straight to eat more chicken. The final witness we called was Ryan French. Ryan told us more about the way that the day's events unfolded and told us that Drew is a good woman who would never commit such a heinous act. Ryan told us that there were protesters that day and the chaos of the restaurant made it difficult for even the most dedicated employees to focus. Their witnesses, however, tell the rest of the story. They bring Bryson Saylor to the stand, who tries to establish her point of view of the day. Ms. Saylor sent the first direct message, as she testified to in cross, sending a threatening message the day before the incident. Ms. Saylor was furious leaving the office on September 5th, the next day. So furious that she probably screamed at her accountant and was sure that she slammed her desk and threw a pin. Immediately after receiving her financials, which were down 25%, in her fit of fury, she drove to eat more chicken to supposedly try the food. Ms. Saylor testified that she took a bite of at least 1 inch in diameter, chewed it, and still couldn't even feel the screw in her mouth before swallowing it. She was able to scream, yell, and tell the medical staff what she'd swallowed, even though the 1 inch screw was well down her throat at that time. Dr. Karras tried to tell you that Ms. Saylor went through significant damage and anguish, but we admitted the patient's discharge papers into evidence, which Dr. Karras certified and verified, and said that the patient's teeth and esophageal lining were undamaged. Ultimately, it's the teeth that matter here. Had Bryson bit into the hard metal screw, there would likely have been damage. It's very strange that Bryson could have unknowingly swallowed a screw about half the size of my pinky finger without biting into it. Thankfully for Bryson, all harm was avoided, but the burden of proof for damage has been unshouldered by the plaintiff. Ultimately, the lack of damage done to Ms. Saylor, as shown in the discharge papers, speaks volumes. There was no damage done to Ms. Saylor from either the screw or following procedures. They called Avery Andrews to the stand. Avery fails to show up to work on time, and when the incident was occurring, Avery was fast asleep in a closet. She testified that on the day of the incident, the restaurant was full with an unusually busy lunch rush. The presence of so many people in the restaurant introduces an inordinate amount of doubt into the case. It was only Bryson screaming after the fact that woke Avery up. Avery Andrews was quite hindered that day, with very little sleep and a ridiculous amount of chicken protesters swarming the area, and the lack of her glasses, which made it so she couldn't even recognize Bryson Saylor. Ultimately, our justice system grants Drew Jennings the presumption of innocence, and the testimony today shows that the plaintiff cannot prove with a preponderance of evidence that Drew Jennings committed civil battery. There are too many factors in the equation. The lack of damage to Bryson's teeth, the screws on the premises, the swarm of protesters inside the building, and most importantly, the lack of a single witness who actually saw Drew Jennings plant the screw in Bryson Saylor's sandwich. All of these introduce doubt into the case that cannot be overcome.
Objection. I believe opposing counsel's time is out.
Hold on. I didn't get any time warnings from. Oh.
Yep, okay. It's up to the bailiff. I don't know, Madam Bailiff.
Oh, I didn't. Sorry, I thought we were doing time signals on these, but I didn't get any. Okay.
I'll give you 15 seconds to sum up.
No, thank you, Your Honor. So long as there's any doubt in your mind that it is 51% likely that Drew Jennings was the very person who put the screw in that sandwich maliciously, you must rule in favor of Drew Jennings. Thus, we ask that you return the verdict in favor of the defendant, Drew Jennings. Thank you, Your Honor.
Madam Bailiff, I think the plaintiffs did reserve up to 1 minute. Were they able to do that?
Thank you.
You have 34 seconds, I believe.
Thank you, Your Honor. Before I begin, although we are not allowed to do substantive objections during an opening statement and closing argument, I just want to bring to the court's attention a couple of misrepresentations in opposing counsel's closing argument. First of all, opposing counsel said that Taylor Tarr saw screws on her desk, on Bryson Saylor's desk, which actually never came out under trial. And secondly, I believe that opposing counsel said that you have to believe beyond a reasonable doubt, or if you have even a 1% doubt that Drew Jennings or that Bryson Saylor did not do this, et cetera, et cetera. This is not the charge for today. It is under preponderance of evidence, so like 50-50 rather than beyond 1% doubt. So I just wanted to make those clarifications clear.
Anything else?
That is all before I begin my rebuttal. Thank you.
You may begin.
At the beginning of defense closing, Mr. Overton gave you 3 requirements for the charge of battery. His first was offensive physical contact, which we proved through Dr. Carez, who testified to the screw and invasive procedures that Bryson experienced. Second, he claimed that you needed motive. Ms. Jennings said herself that if Bryson's Chicken Kingdom crumbled, she would get more customers and therefore more profit. Motive clear as day. And finally, Mr. Overton said you needed harm, which we proved through Bryson Saylor's terrible and painful experience of swallowing a screw and undergoing an endoscopic foreign body removal. We have satisfied opposing counsel's 3 requirements to be a charge of battery. It is more likely than not that Drew Jennings committed battery against my client. Thank you.
Now, Madam Bailiff. Can we get you to come on just a second, please? Ursula?
Okay, yes.
All right, there you are. Now, the first round did this morning, there were 3 scores, so you didn't need anything as far as scoring from me. Is that still correct?
We'd ask that is correct, yes.
Okay. Then they'll be submitting their scores. They're doing it electronic, I think, this time. If they are through, I'll give the scores opportunity to introduce themselves and have any just brief comments if they'd like to do that. Are they ready or?
I'm finished with my scores.
All right. Okay. If you'll introduce yourself and.
Okay. Hi, guys. I'm Rachel Moses, and I am an attorney with the Legal Aid Society in Cookeville. I'm also one of the past presidents of the Tennessee Bar Association Young Lawyers Division, so I've seen quite a few of these over the years. Congratulations on making it to the state competition. Felt like it was a fantastic round. And I'm not going to bore you with comments about how to be better. I know some of my colleagues have a little bit more experience than I do in coaching some mock trial and actually participating in mock trials. So they may have some comments. But I'm just proud of you, and I think you guys did an awesome job.
Next score ready? Thank you.
Sure, I can go. Hi, everyone. My name is Shelby Dodson. I also work at the Legal Aid Society with Rachel. I'm in our Gallatin office. I just want to say great job to everyone. This has been really fun. And just something that I said to the team I scored. I gave you all most of you lots of feedback on your score sheet, so you can refer to that. But something I told the group yesterday, which was a surprise to me, is I was a student in this competition in 2009 and 2010, and I got barred in 2016. So you're not as far away as you think you might be, or as it feels. And see you all soon.
Thank you.
All right, I'll go last.
Shelby.
Oh, thank you, Judge Conley. Hey, y'all, I'm Kristen Korn. I am the city attorney for Brentwood, Tennessee, so I'm like in-house counsel. As Rachel said, I was just like her. I was involved in mock trial as the mock trial chair for a couple years. And so I've seen a ton of these and just want to commend you all on a really good job. As I said to the two teams that I watched last night, you all did a fantastic job, even considering that we're a normal mock trial year, but then throw in the Zoom aspect, and I was just really blown away. So you all should be very proud of the hard work that you've put into it and the resulting outcome. You guys have done just a really fantastic job, and I know that your grown-ups and your coaches are as proud of you as they should be. So really nice work, guys.
Thank you, Kristen. I'll sum it up here. My name is Paul Conley. I'm the General Assistant Juvenile Court Judge, Crockett County. I've judged several of these these contests too. And so I congratulate both teams. Your coaches obviously worked hard and you spent a lot of time in preparing. One of the things that makes this contest a little different is that every judge is going to view things a little differently. Sometimes you may object to a particular piece of evidence or a statement, and one judge may allow it in, the next judge may not. So you have to be able to think on your feet and adjust your statements accordingly, because sometimes something will come in, sometimes it won't. And I think you all did a good job of that. You've been coached well by your coaches doing that. I think also you need to be aware, if you're doing your closing, opening you can write out and have it memorized. Your closing, you need to adjust to the testimony that was given that day. And that may be what you had prepared. It may not. The judge may not allow something in, or may allow something in that you weren't prepared for. And I think when that happens, it's a really great opportunity for you to really pick up some points by adjusting to things as they go. So I congratulate both teams. It's been a long day for both of you. Somebody's going to advance, I guess, to the finals tomorrow. Kristen, I guess that's when they'll be. Or they be tonight?
They're tonight.
Yeah, okay, they're tonight. So I
5
congratulate
o'clock.
everybody's hard work. If there's nothing else, Ursula, do we have anything else?
Well, Your Honor, there's some announcements we need to make.
Okay, if you want to do those.
Yes. Hi, everyone. The award ceremony will start at 4:30 Central. Students can join the award ceremony via Zoom. Look for that link in process. Parents, spectators, everyone else will ask that you join via YouTube. Look for that link. We will send it out via email. It's going to be on Twitter, and it will also be in process as well. That's the only announcement we have.
If nothing else, then congratulations to both teams. Good luck to everybody.
Thank you guys so much all for taking the time to do this. We really appreciate it.
All right, good luck to you. Coach adjourned.